Step away from the vehicle. You're coming with us. We don't need to explain anything.
You are standing on private property. You do not have a warrant. You do not have legal authority to detain me.
Ma'am, I don't care who you think you are.
At exactly 7:14 in the morning on a quiet residential street in Alexandria, Virginia, a routine drive to the courthouse turned into a constitutional crisis that would shake the Department of Homeland Security to its foundation. The body camera footage and a neighbor's doorbell video would later go viral, racking up over 47 million views in less than a week. But this wasn't your typical police encounter video. This was different. This was a sitting federal judge, appointed by the President of the United States, confirmed by the United States Senate, being physically detained in her own driveway by ICE agents operating without a warrant, without judicial authorization, and without a single shred of legal justification. What happened next would stun the entire legal community, spark a firestorm inside Congress, and prove once and for all that a badge does not make you above the Constitution. Before we go any further, do me a favor and drop a comment letting me know where you're watching from. And if you haven't already subscribed, please do it now. Because this story gets even more extraordinary, and you do not want to miss what comes next. Judge Imani Carter was not your average 27-year-old. While most people her age were still figuring out what they wanted to do with their lives, Imani Carter had already been confirmed as a United States District Court judge for the Eastern District of Virginia, making her one of the youngest federal judges in American history and the youngest black woman ever to hold that title. But to understand why this morning in her driveway ended the way it did, you have to understand who she was before any of this happened. Imani Carter graduated as valedictorian from Howard University in 2017 with a double major in political science and African American studies. She went straight to Yale Law School, where she finished at the top of her class and served as editor-in-chief of the Yale Law Journal. After Yale, she was selected as a law clerk to a sitting Supreme Court justice, one of the most competitive and prestigious positions in all of American law, where she spent 2 years helping draft opinions that shaped federal jurisprudence. Before she ever put on a judicial robe, she had already published an academic paper specifically on Fourth Amendment violations by federal immigration enforcement agencies, a paper that had been cited in 3 separate federal court rulings. She wasn't just a judge. She was one of the most qualified constitutional minds in the entire country, and she was about to prove exactly that, standing in her own driveway in her courthouse blazer holding a travel mug of coffee. On a Tuesday morning in October, Judge Carter was doing what she did every single day, preparing for a full docket at the federal courthouse 12 minutes from her home. The neighborhood was calm. Leaves were just beginning to turn on the oak trees lining the street. A few neighbors walked their dogs in the early morning chill. Everything was ordinary. Everything was peaceful. She walked out of her front door carrying her leather briefcase, a stack of case files, and that coffee mug. She was not speeding. She was not evading anyone. She was not doing anything that any reasonable person could describe as suspicious in any way. She was simply a woman walking to her car on a Tuesday morning. Then 2 unmarked black SUVs pulled into her driveway and blocked her vehicle completely. 3 men in tactical vests stepped out, ICE insignia on their chest. No marked vehicles, no sirens, no prior contact of any kind. Most people in that moment would have felt their stomach drop. Most people would have panicked, tried to explain themselves, or simply complied out of fear. Imani Carter felt something different. She felt recognition, the kind of recognition that comes from years of reading Fourth Amendment case law, from clerking at the highest court in the land, from knowing, with absolute certainty, that what was unfolding in front of her was not just wrong, it was illegal. The lead agent was Senior Deportation Officer Dale Kowalski, 14 years with ICE, a man who had described himself in his own personnel evaluation as, quote, aggressive but effective. He had made hundreds of enforcement contacts. He was used to people flinching. He approached Judge Carter with the kind of confidence that comes from almost never being questioned. "We need you to come with us," Kowalski said, his tone flat and completely non-negotiable, as if the conversation were already over. Judge Carter set her briefcase calmly on the hood of her car. "On what authority?" she asked. This is the moment where everything started to unravel for Dale Kowalski, though he didn't know it yet. He reached into his tactical vest and produced a document, handing it to her. "We have a civil removal order for an Imani Carter at this address." She took the document. She reviewed it for exactly 11 seconds. Then she looked up. "This is an administrative removal order," she said. "It was not signed by a judge. It does not constitute a judicial warrant. It does not authorize entry onto private residential property under the Fourth Amendment, and the individual named on this document has a date of birth of 1971. I was born in 1997. This document is not for me. You have the wrong person. Kowalski stared at her. Ma'am, we have reason to believe. She stopped him. Do not call me ma'am. My name is Judge Carter. I am a sitting United States District Court judge, appointed under Article 3 of the Constitution of the United States. You are standing on my private residential property. You have blocked my vehicle, and you are attempting to detain me without a judicial warrant, without exigent circumstances, and without my consent. What you are doing right now is a violation of the Fourth Amendment to the United States Constitution. It is a potential civil rights violation under Title 42, United States Code, Section 1983. And depending on how the next 60 seconds go, it may also constitute a federal crime. The body camera captured Agent Kowalski's jaw tighten. His partner, Agent Reyes, shifted his weight. The third agent on scene quietly took a half step backward. They had never encountered anything like this. In hundreds of enforcement contacts, no one had ever responded this way. No one had known the difference between an administrative order and a judicial warrant. No one had ever cited the specific federal statute by number, standing in a driveway, without a single note to read from. No one had ever been a federal judge. Quick question for everyone watching right now. Do you think ICE agents should be legally required to verify a person's identity before initiating any kind of detention? Drop your answer in the comments. I want to know what you think. Kowalski made the decision that would define the rest of his life. You're being uncooperative, he said. We're detaining you for questioning. Judge Carter looked directly into his body camera lens. Deliberately. Calmly. As if she already knew exactly who would be watching that footage later, she opened her credentials wallet and held it up. Gold badge. Federal court seal. Her photograph. Her name. Her title. I am not obstructing. I am not fleeing. I am standing in my driveway in professional attire. I am showing you my federal judiciary credentials. I am invoking my right to be free from unreasonable seizure under the Fourth Amendment. I am not consenting to this detention, and I am informing you that this encounter is currently being recorded by at least 2 external cameras in addition to your body camera. She pointed across the street to her neighbor's Ring camera. Then she pointed to her own front door. Then she looked back at him. She said nothing else. Kowalski grabbed her arm anyway. Across the street, a retired attorney named Martin O'Coffer had stepped onto his porch when he heard the SUVs. He was already filming on his phone in 4K, and he was already scrolling to his contact at the Washington Post. Imani Carter was placed in the back of the SUV. She did not resist. She did not raise her voice. She sat down, straightened her blazer, and said one final thing to Agent Kowalski before the door closed. You have 48 hours. After that, I will be in a courtroom, and you will not. Within 22 minutes of those doors closing, 6 things happened at the same time. The Chief Judge of the Eastern District of Virginia received a phone call. The United States Marshal's Service was notified. The DOJ Civil Rights Division received an emergency alert. 2 senior DHS officials saw a text message from a colleague that read simply, Dale picked up a federal judge. The director of ICE was pulled out of a morning briefing, and Martin O'Coffer's video was already uploading to the internet. At the ICE field office, Kowalski had just started processing paperwork when his supervisor appeared in the doorway with an expression that Kowalski would later describe as the kind of look that changes a room. The supervisor asked one question. Did you check her credentials? The body camera footage recorded the silence that followed. He had not. He had looked at a young black woman in a driveway and moved forward on assumption. No verification. No identity check. None of the steps that ICE's own operational guidelines required before residential enforcement contact. Meanwhile, Judge Carter was sitting in a holding area, still in her blazer, and she had asked for a pen and paper. She was writing entirely from memory. Case citations, statutory references, a precise timeline of every second of the encounter, the exact words spoken by every agent on scene. When an officer walked past and glanced at what she was writing, she looked up calmly and said, Is there a senior attorney in this building? Because whoever that is, they are about to have the worst day of their career, and I would like to give them the courtesy of knowing it is coming. She was released 71 minutes after she was detained. A personal call from the Deputy Attorney General to the ICE Field Office Director ended the situation before it reached 2 hours. Now, most people who experience what Judge Carter experienced go home and spend days or weeks just processing what happened. Maybe they tell a family member. Maybe, months later, they file a complaint that gets lost in a pile somewhere and never goes anywhere. Imani Carter was not most people. By 4:01 in the afternoon of the same day, she had filed a 34-page formal complaint simultaneously with the DHS Office of Inspector General, the Department of Justice Civil Rights Division, and the ICE Internal Affairs Unit. She had submitted preservation demands for all body camera footage, all SUV GPS data, all radio communications, and the original administrative removal order. She had filed a Freedom of Information Act request within the same hour. The complaint was not written like a victim statement. It was written like a federal court opinion. It cited 11 specific constitutional violations. It named every agent on scene by name and badge number. It included a detailed legal analysis of why the administrative removal order failed to meet the constitutional standard for residential contact. And it included a section with a title that would be quoted in every news article written about the case for the next 3 months. The section was called Pattern and Practice. Why this was not an isolated error. The DHS Inspector General's office received the complaint on a Tuesday. By Thursday, Agents Kowalski and Reyes had been placed on administrative leave. The third agent had already retained private legal counsel. To understand why that timeline is extraordinary, you have to know that these investigations normally take months just to send an acknowledgement letter. The fact that 2 agents were placed on leave within 48 hours tells you everything you need to know about how airtight that complaint was. The investigator assigned to the case was a 20-year veteran of federal internal affairs named Sandra Cho. She pulled the body camera footage and watched it once. Then she called her supervisor in and watched it again. Then they called in the Deputy Inspector General and watched it a third time. What they saw confirmed everything in Judge Carter's complaint, and then went further than even she had documented. Agent Kowalski had never once asked for identification before initiating the detention. The administrative order was for an entirely different person with a different date of birth and a different physical description. Agent Reyes had been captured on audio saying, "She looks undocumented," before a single word had been exchanged. All 3 agents had bypassed every identity verification step that ICE's own guidelines require before residential contact. And Kowalski had physically grabbed Judge Carter's arm 11 seconds after she had clearly and verbally invoked her Fourth Amendment rights, on camera, with witnesses present. But what made the investigation even more serious was what investigators found when they cross-referenced the address with ICE's operational records database. The same field office had flagged that same residential address 3 separate times in the previous year. 3 different agents, 3 different contacts. And in every single case, agents had made contact with residents at that address without a judicial warrant, without proper verification, and without following protocol. The address had been incorrectly linked to an enforcement target in the database years earlier. And in all that time, no one had corrected it. No one had audited it. No one had caught it. Judge Carter's case hadn't just exposed 3 agents who made a bad call on one morning. It had blown open a systemic, office-wide failure that had been operating unchecked for years. The full investigation took 61 days from filing to final report. For a federal internal affairs review, that is almost unheard of in terms of speed. But the evidence left no room for delay. The official findings from the DHS Office of Inspector General were released in a 28-page report that is now publicly available. Agent Dale Kowalski had violated Fourth Amendment constitutional protections through the unlawful warrantless detention of a United States citizen on private residential property. Agent Marcus Reyes had made a racially presumptive statement on audio that constituted potential civil rights violations under federal law. The ICE field office had maintained inaccurate enforcement database records for years, resulting in repeated improper contacts at the same address. All 3 agents on scene had bypassed mandatory identity verification protocols required by ICE's own operational guidelines, and field office supervisors had failed to provide oversight that would have caught these violations long before they escalated to this level. The report recommended termination for Kowalski and Reyes, mandatory retraining across the entire field office, and a full database audit for similar errors nationwide. Agent Kowalski resigned before the formal termination could be processed. His 14-year career ended because he grabbed the arm of a woman he never verified, never identified, and never had any lawful authority to touch. Agent Reyes was terminated. The third agent was demoted and formally reprimanded. The field office director was transferred and stripped of his supervisory role. Everything had been recorded. Everything had been witnessed. Everything was documented in a 34-page filing by the woman they had tried to detain. Everything was undeniable. DHS initially attempted to limit public access to the full Inspector General report, citing operational sensitivities. Judge Carter's legal team filed a FOIA lawsuit within the week. The report was released in full within 30 days. When the body camera footage and the neighbor's doorbell video were released together, the internet responded in a way that few stories do. The combined footage was shared over 90 million times across social media platforms. CNN, the BBC, NPR, the New York Times, and dozens of international outlets ran the story. Constitutional law professors across the country broke down the footage frame by frame on YouTube channels with millions of subscribers. Law schools added the case to their Fourth Amendment curriculum within the same semester. Congressional hearings were announced within 2 weeks of the footage going public. The reactions were not all the same. Some people praised Judge Carter for her composure, her precision, her refusal to either escalate or submit. Others raised a harder point, that she was, in their words, lucky to have been able to articulate her rights the way she did, and that the vast majority of people in that driveway wouldn't have known what to say. Some argued she should have complied to stay safe. Others pointed out that compliance has not historically protected people who look like her from encounters that turn violent. The debate was loud and it was real. But there was one thing that no one on any side could challenge. She was right. About every legal point. About every statute. About every procedural violation. Every single thing she said in that driveway held up under a full federal investigation. All of it. Do you think the consequences handed down were sufficient? Or should there have been criminal charges? I want to know what you think. Drop your answer in the comments. In the 6 months following the incident, the ICE field office in Alexandria implemented sweeping changes. All agents conducting residential enforcement were required to complete mandatory judicial warrant training. The entire residential enforcement database was audited and corrected. A new identity verification protocol was put in place requiring government-issued identification checks before any residential contact could be initiated. New supervisory review requirements were established for all administrative removal orders before field deployment, and civil rights training became a mandatory annual requirement for every agent in the office. In other words, they made their agents learn what Imani Carter had known since law school. After the footage went viral, 4 other residents of the same neighborhood came forward with their own accounts of improper ICE contact at their homes. A family on the next block who had been approached without a warrant. A woman 2 streets over who had been questioned at her door. A man who had been briefly detained the prior year and had told no one because he didn't think anyone would believe him. Each account followed the same pattern: no warrant, no proper verification, an assumption of guilt based on appearance. Each of these individuals had rights they were never told about and never had the legal training to assert. The question that case raised, and that Congress began formally investigating, was this: how many other addresses across the country have the same database errors? How many people have been contacted, detained, or worse, not by agents acting maliciously, but by agents operating on uncorrected data and unchecked assumptions? And how many of those people are still waiting for someone to believe them? Judge Imani Carter returned to the federal bench 4 days after the incident. She has since authored 2 federal opinions that have already been cited by courts in multiple circuits. She established a pro bono legal clinic in Alexandria dedicated specifically to helping individuals who have experienced unlawful enforcement contact, offering free legal counsel, complaint filing assistance, and know your rights education to anyone who walks through the door. She has spoken at 12 law schools across the country. She testified before the Senate Judiciary Committee on Immigration Enforcement and Constitutional Compliance. She was named to the National Bar Association's list of the most influential jurists in America under the age of 40. She has never spoken publicly about the morning in her driveway with anger, only ever with the same calm clarity she showed on camera. Agent Dale Kowalski is no longer in federal law enforcement. He has made no public statements. Here is a question I want to leave with you before we talk about the bigger picture. If you had been standing in that driveway, not a federal judge, not a constitutional law expert, just you, would you have known what to say? Would you have known the difference between an administrative order and a judicial warrant? Would you have known you had the right to ask for one? Drop your honest answer in the comments below. This story is not just about one morning in one driveway in Virginia. It is about the assumption of authority without accountability. It is about who gets believed and who gets questioned before a single word is spoken. It is about what happens when systems meant to protect the public target the wrong person. And that person happens to have the knowledge and the standing to fight back in a way that cannot be ignored. Most people in that driveway would not have known that an administrative removal order is not a judicial warrant. Most people wouldn't have known that residential property requires a higher legal threshold for enforcement contact. Most people wouldn't have known to invoke their Fourth Amendment rights by name and statute number on camera. Some of those people right now are sitting in places they should not be, because of database errors no one caught and assumptions no one questioned. Some enforcement agents, not all, but some, rely on that gap in knowledge. They rely on the fact that most people don't know the difference between an order and a warrant. They rely on compliance rooted in fear rather than law. They count on people being too scared, too uninformed, or too intimidated to ask the single most important question in that moment. Where is your warrant? When that question gets asked by someone who cannot be dismissed, by someone who knows the answer before the agent does, by someone who is going to file a 34-page complaint by end of business that same day, the power dynamic shifts in a way that cannot be reversed. The badge does not automatically end the conversation. The tactical vest does not automatically command constitutional authority. Knowledge becomes the equalizer. And sometimes, not always, but sometimes, knowledge wins. So what do we take from all of this? What does Judge Carter's story actually mean for the rest of us? First, knowing your rights is not enough on its own. You have to be able to articulate them calmly, clearly, and on the record. Panic is the enemy of protection. The moment you can clearly and calmly state what is and is not legally permissible, you change the dynamic of every interaction. Second, documentation is everything. Judge Carter's neighbor filming from across the street changed what was recoverable from that morning. Your phone is a legal instrument. Use it. Third, the complaint matters. Filing a formal, detailed, documented complaint is not the same as venting online. It creates a legal record. It triggers preservation requirements. It starts a clock. And when it is written the way Judge Carter wrote hers, it cannot be ignored. Fourth, patterns only become visible when individuals report them. The 3 prior contacts at that address were invisible until someone with the standing and the skill to connect the dots filed something that forced investigators to look. One person filing one complaint exposed a years-long systemic failure. Fifth, accountability is possible. It is not guaranteed. It is not easy. It does not happen fast enough or often enough. But this case proves that it can happen, and that when it does, it matters beyond the individuals involved. One woman, one driveway, 71 minutes, and the end of multiple federal careers, a congressional investigation, a policy overhaul, and a legal record that is now being taught in law schools across the country. That is the power of preparation. That is the importance of knowledge. That is what happens when someone refuses to be smaller than their rights. Final question for you. What is one thing you learned from this story that you did not know before you started watching? Drop it in the comments. And if this story moved you, share it, because the reality is, most people who have experienced what Judge Carter experienced did not have her credentials, her training, or her platform. They had the same rights, they just did not know it. And that is exactly the problem this story should make all of us want to fix. This story matters because it is not just about Imani Carter. It is about every person who has ever been approached in their driveway, at their door, or on their street and felt too afraid to ask a single question. It is about every database error that was never corrected because no one with the power to force a correction ever ended up in the crosshairs. It is about every complaint that was never filed because the person filing it did not believe anyone would take it seriously. Judge Carter's story shows that you can know your rights. You can assert them. You can document everything. You can file the complaint. And sometimes you can win. Not every story ends this way. Not every encounter results in accountability. Not every filing leads to change. But this one did. And that matters more than most people will ever know. That is her legacy. Not just the removal of 3 agents from the field, but the proof, delivered on camera, in real time in her own driveway, that the Constitution belongs to everyone, and that no one, in any vest, carrying any order, driving any unmarked SUV, gets to take it away without consequence. This has been the story of how ICE agents' careers were destroyed after the arrest of a 27-year-old black federal judge in her driveway without a warrant. But more than that, it has been a story about what happens when knowledge meets power and refuses to blink. This story is presented for educational and informational purposes only. All individuals depicted are fictional and any resemblance to real persons is coincidental.